My next guest is well known to viewers not only of this platform but of many channels, Chris Merritt. He's Vice President of the Rule of Law Institute, and he is without doubt Australia's leading media commentator on legal matters. Welcome, Chris.
Hi, David.
Chris, I want to show you something and then I'll ask you what it means. Now, what
This sounds ominous.
Now, this is a cartoon by Johannes Leek in The Australian. What does it all mean? What's it all about?
Well, there is a possibility, let me put it that way, there is a possibility that there is now likely to be an examination of the circumstances leading to the settlement, the government settlement with Brittany Higgins, where she was paid $2.4 million to settle potential claims of hers based on a deed which, according to Justice Lee in the federal court, in the defamation proceedings recently concluded, contains a series of misstatements, let me put it that way, concerning the conduct, her treatment, Miss Higgins's treatment by her former employers, Linda Reynolds and Michaelia Cash. Now, that payout was based in part, the major part, on assertions that she was mistreated after she made accusations that she was sexually assaulted. Now, the sexual assault has been stood up, if you like, on the civil standard of proof. But the workplace claims of bullying and victimisation and isolation, discrimination, they have not. And why is this significant? Because the two people who are best, or would have been best placed to test the veracity of Miss Higgins's claims of mistreatment, her former employers, Reynolds and Cash, were intentionally excluded in the face of financial coercion from the mediation that led to that payout. The government said, look, if you insist on going along and having your say, well, we'll tear up our agreement with you to pay your legal costs. So there was a financial penalty had they decided to go ahead and dispute the assertions of mistreatment that were the basis for the payout of $2.4 million. So now that the defamation proceedings are concluded and the truth of those assertions has been questioned by the federal court, I think it's almost inevitable that the circumstances of the payout will need to be examined. Now, that could be the National Anti-Corruption Commission. It could be the Australian National Audit Office. But the way I see it is there's a systemic problem. The way the rules governing compensation payments from the Commonwealth go, that they on first blush, they look elaborate and they're full of checks, and you've got to have a lawyer's opinion that there's a reasonable prospect of liability being found against the Commonwealth. Sounds great. You might even have to get an outside lawyer's opinion, not just the Australian government solicitor, but an independent lawyer's opinion. Sounds great. Except when you get right down the bottom of these rules, and they're in a document called the Legal Services Directions, you get right down the bottom, and there's a loophole, an enormous loophole, and it says that if the Attorney General determines that exceptional circumstances apply, well, the attorney can simply dislodge those normal rules and impose his own rules. Now, I suspect that that's exactly what's happened in the Higgins payout, because it would be extremely unlikely that any lawyer, a government lawyer or a private lawyer, would sign off on a payout based on a mediation where only one side of the argument has been heard, and the employer's point of view has intentionally been excluded from the process. Now, for anybody to say that is consistent with legal practice and legal principle, I think that would be a courageous assertion. So I don't think it would be backed by an independent lawyer, which I suspect means that the loophole would apply, the exceptional circumstances loophole. Now, when the National Anti-Corruption Commission comes to decide what matters it's going to look at, some of the factors it considers is whether there's a systemic problem, whether there's a not just a problem in one circumstance, but a problem that has an ongoing, a potential ongoing impact. Now, it's my view that the weakness of the legal services directions leaves the way open for a similar arrangement to take place. Who knows for what reasons, but it's the lack of rigour in that loophole, I think, needs to be closed. And the Higgins payout is the perfect opportunity for either the National Anti-Corruption Commission or the Audit Office to dive in and have a good look at this and say, well, is this really rigorous? Do these rules mean anything? And on the face of things, and on what we now know, thanks to the Justice Lee in the federal court, I don't think those rules are worth much, quite frankly. I think they definitely need to be reformed. And that's what that cartoon was all about.
And the judge in that case, we're not talking about rape, are we? We're not talking at all about that question. We're just talking about whether she was badly treated, improperly treated, in relation to her claim that she was the subject of a rape in Parliament House. That's what the issue is.
That's the overwhelming nature of her claim. It was, she said, look, I'd been sexually assaulted, and then all these bad things happened in my workplace. So the sexual assault was the basis of it, but then the conduct of the two ministers in the coalition government came into play. So the sexual assault was part of it, but it was not the main part. The main reason for the deed of settlement was the conduct, or the alleged conduct, of the two ministers, which has now been shown to be without substance.
And your detailed opinion on this can be seen in your article in The Australian last Friday, but it's also, is it not, on the Rule of Law Institute webpage?
Yes, that's right. The Rule of Law Institute has been arguing for years now that there's a problem with the legal services directions, not just the provision that deals with payouts, but there's other provisions that deal or impose a requirement on the Commonwealth to conduct itself as a model litigant. And that sounds great too, except for the fact that it's completely unenforceable. So if you're engaged in litigation against the Commonwealth agency, and you suspect that or it becomes apparent that the Commonwealth has not been conducting itself as a model litigant, you have no recourse. This is aspirational as the highest I would put it. It's not. It doesn't fall into the same category as a regulation enforceable by a disappointed litigant who's suffered at the hands of a Commonwealth agency in legal proceedings. So there's an overall problem with the legal services directions. They're aspirational, but there's loopholes. They're unenforceable. There needs to be a complete review of these provisions. There's too much leeway left to Commonwealth ministers and Commonwealth agencies, even when wrongdoing's been found by Commonwealth agencies. Unhappy litigants in the private sector have no recourse under these rules, and they should have.
And in relation to the mediation, what sort of person, what category of person would have actually run the mediation? Would that have been an employee of the Commonwealth or someone independent from outside?
As I understand it, it was run by the Department of Finance. So I'm assuming that this would be reasonably senior officials in the Department of Finance, which could itself be a problem. It would be preferable if there was an independent mediator involved, a senior member of the bar, for example.
Yes.
Lots of barristers do this, and they're very experienced at how these things should run.
Yes.
And I wouldn't say that about government officials.
Yes. And we can't say that the mediator would have known that the principal potential witnesses were given a disincentive, a very strong disincentive, not to appear.
Yeah, whether or not they knew, I think the bottom line is these officials were put in a position where they were not able to properly defend the financial interests of the Commonwealth. They were deprived by persons unknown. We don't know who exactly excluded the two coalition ministers, but the persons unknown, in my view, nobbled that mediation and ensured that the officials, even with the best of intentions, these officials did not have sufficient information before them to have a complete view of the true circumstances. And Justice Lee has made this very clear, that there was simply no substance to the argument that Linda Reynolds and Michaelia Cash conducted themselves in a way that discriminated against or victimised Miss Higgins. And as you rightly said, this is an argument about workplace conduct. It's not an argument about whether she was sexually assaulted. That's been resolved on the civil standard at least.
Yes. And before we go, I suppose it's worth noting, of course it wouldn't be appropriate, I should think, given your comment, it is obvious that there was distinct political advantage in the almost following election in this matter, but that's not a matter which perhaps you wish to get involved in.
Well, look, I think when you've got these issues swirling through Parliament House, and there's no doubt about it that this was a cause célèbre, a political issue. Just for the sake of transparency and certainty, it would be good to have this entire process reviewed so that the community could be certain one way or another about exactly what happened.
Well, thank you very much for giving us your time. And in conclusion, as Brittany Higgins says in the cartoon, if we have to give the money back, can we at least keep the card? Thank you very much, Chris Merritt. And as I mentioned, people can see this on the details, the very well argued position on the Rule of Law Institute webpage.